Hi, this is Attorney Max Majeski of MJM Law Office, and today I'm going to be talking a little bit about the criminal justice system in general. Now, you may have been arrested for a DUI or a felony assault or something like that, and maybe wondering, what is this going to be like to go through this criminal justice system? So, if that's the case, this video is for you. The first thing that'll happen after your arrest is you'll be issued a citation. Now, you might have been lodged in the jail and had to post bail to get out, or maybe you were released on your own recognizance with a citation to return to court. That's going to have a date and time and location on it. It might be something like Eugene Municipal Court, 1102 Lincoln Street, or the Linn County Circuit Court, or maybe you're in a court in another county. That'll tell you your first appearance date, also known as your arraignment. Now, it's a good idea to get in contact with an attorney prior to that arraignment so that they can get on board, appear for you at the arraignment. That would be mostly an optional appearance. If it's a misdemeanor or if it's a felony, you would also have to appear at that arraignment. The arraignment is just going to get the case started. Sometimes people see that date and think it's their trial. Well, that's nowhere near the trial. This is the time frame where the city prosecutor or district attorney is reviewing the case, all of the police reports, videos, everything else taken by the police, and that citation is what the police think you should be charged with. The arraignment is when you're going to find out what the attorney thinks you should be charged with. So that city prosecutor or district attorney will file charges on that date. Your attorney will go in there, or you'll go in and you'll be given a copy of what's called an information. If it's a felony, it might be an indictment. It might have already gone through grand jury. And that's going to tell you what your charges are. That's really going to start your case. At that point, we would shortly after that be able to get all of the discovery in your case. The discovery is basically all the evidence that the state has to try to prove the charge beyond a reasonable doubt. And we would get copies of all that. That includes police reports, the video, in-car video. The Eugene Police Department now has body-worn video, any kind of 911 call recordings, all of that information we would receive and start reviewing to understand what the state's case is against you. At the same time, we would start doing our investigation to understand what potential defenses you have. We would interview you, interview any witnesses, get a sense for the case. And at the arraignment, you'll generally set another court date about 30 days out. And this is going to be a status date. Now, if you're eligible for DUI diversion, you would set your DUI diversion date, and that'll be within the next 30 days. So at that next hearing, called usually your status hearing, we would go back to court. And at that point, we'll have a pretty good idea of what your options are as far as whether you're considering taking a plea deal or you just want to set the case for trial. Now, if there is something that your attorney has been able to negotiate with the DA or city prosecutor, that's something that could happen on that next court date where you go in and you do what's called a change of plea. Maybe you plead to one charge and they dismiss another charge, something like that. And then we would have what's called a sentencing hearing. Now, the sentencing hearing is where you will explain to the judge kind of a little bit about you, about what happened. The DA will say a bunch of bad stuff about you, and we'll talk about what the appropriate sentence should be. Now, usually we'll have a joint recommendation to ask the court to follow. However, it'll be up to the judge who sentences you to impose whatever sentence is available. And that could be anything up to that maximum sentence of a year in jail and $6,250 on a misdemeanor, or wherever you fall in the felony sentencing guidelines. Now, if that is not going to be an option because we can't work out a deal that's appropriate, then we would set your case for trial. And trial is going to probably be another 60 to 90 days from that second court date, so a few months out from your initial arraignment. And that's when we would really prep your case, go in and have the entire trial process to try to get an acquittal on your case. If you have any other questions about your options or the legal process, if you've been arrested or charged with a crime, feel free to give us a call. Again, this is Max Majeski, MJM Law Office. Thank you.